Scope of Article 14. The true meaning and scope of Article 14 has been explained in several decisions of the Supreme Court. The rules with respect to the permissible classification as evolved in the various decisions have been summarized by the Supreme Court in Ram Kishan Dalmia versus Justice Tendulkar as follows. Article 14 prohibits class legislation but does not forbid classification. Permissible classification must satisfy two conditions, namely, it must be founded on an intelligible differentia which distinguishes persons or things that are grouped together from others left out of the group, and the differentia must have a relation to the object sought to be achieved by the statute in question. The classification may be founded on different bases, namely geographical or according to the objects or occupations or the like. In permissible classification, mathematical nicety and perfect equality are not required. Similarly, non-identity of treatment is enough. Even a single individual may be treated as a class by himself on account of some special circumstances or reasons applicable to him and not applicable to others. A law may be constitutional even though it relates to a single individual who is in a class by himself. Article 14 condemns discrimination not only by substantive law but by a law of procedure. There is always a presumption in favor of the constitutionality of an enactment, and the burden is upon him who attacks it to show that there has been a clear transgression of the constitutional principles. A remarkable example of the application of the principle of equality under the Constitution is the decision of the Constitutional Bench of Supreme Court in R.K. Garg versus Union of India. The legislation under attack was the Special Bearer Bonds, Immunities and Exemption Act 1981. It permitted investment of black money in the purchase of these bonds without any questions being asked as how this money came into the possession. In a public interest litigation, it was contended that Article 14 had been violated because honest taxpayers were adversely discriminated against by the Act, which legalized evasion. But the Supreme Court rejected the challenge, taking note of the magnitude of the problem of black money, which had brought into being a parallel economy. Finally, it should be mentioned that Article 14 invalidates discrimination not only in a substantive law but also in a procedure. Further, it applies to executive acts also. In the recent past, Article 14 has acquired new dimensions. In Maneka Gandhi versus Union of India, the Supreme Court held that Article 14 strikes at arbitrariness in state action and ensures a fairness and equality of treatment. The principle of reasonableness, which logically as well as philosophically is an essential element of equality or non-arbitrariness, pervades Article 14 like a brooding omnipresence. The Supreme Court held what Article 14 strikes at is arbitrariness because an action that is arbitrary must necessarily involve negation of equality. Wherever, therefore, there is arbitrariness in state action, whether it be to the legislature or of the executive of an authority under Article 12, Article 14 immediately springs into action and strikes down such action. In this case, the system of selection by oral interview in addition to the written test was upheld as valid, but allocation of above 15% of the total marks for interview was regarded as arbitrary and unreasonable and liable to be struck down as a constitutionally invalid. Position of higher education can be treated as a valid base or classification of two categories of employees, even if no such requirement is prescribed at the time of recruitment. If such a distinction is drawn, no complaint can be made that it would violate Article 14 of the Constitution. In state of Karnataka versus Uma Devi, the Supreme Court has held that the adherence to the rule of equality in public employment is a basic feature of our constitution, and since the rule of law is the core of our constitution, a court would certainly be disabled by passing an order upholding the violation of Article 14.